5 seconds to go. Start. According to the appellant, on 6th April 2019, the said officer received a telephonic information from the superintendent of the said hostel, which is under the control of the Integrated Tribal Development Project Chandrapur, that one girl studying in the 3rd standard and another studying in the 5th standard of the said school were not keeping well. Immediately he visited the hospital where they were admitted. Later he received letter number 3392 of 2019 dated 10th February 2019 revealing that the students were shifted from Rural Hospital Rajora to General Hospital Chandrapur owing to their deteriorating health condition. From the General Hospital Chandrapur, a medical certificate was issued to the effect that there is suspicion of sexual abuse. Thereupon, the project officer integrated Tribal Development Project Chandrapur authorized him to lodge the complaint and accordingly it was laid. We may state at this juncture that going by criminal application APL number 841 of 2019 filed along with the present appeal as Annexure P3, the parents of the victims were not happy with the investigation in the crime and they filed a criminal writ petition number 342 of 2019 and subsequently final report charge sheet number 43 of 2019 dated 8th June 2019 was filed. Now reverting to the case of the appellant, it is to the effect that during the investigation, superintendent of the aforementioned hostel and 4 others were arrested and arraigned as accused in the crime. During the investigation, it was found that 17 minor girls were abused by the accused and on their medical examination, rupture of hymen was found. The respondent herein is the medical practitioner appointed for treatment of girls admitted to the paid girls hostel and the victim girls were taken to him. The investigation revealed that the respondent had knowledge about the incidents occurred from the victims themselves as the victim girls revealed in their statements recorded under section 161 of CRPC about their divulgation of sexual assault on them to the respondent. In fact, some of the victims had specifically revealed it in their statements recorded under section 164 CRPC. The respondent, who was under a legal obligation in terms of the provisions under section 19(1) of the POCSO Act, upon getting the knowledge about committing of an offence under the POCSO Act, to provide such information either to the Special Juvenile Police Unit or the local police, remained silent and did not provide such information to help the accused is the gist of the allegation against him. As already stated, after investigation, a charge sheet was also filed. The respondent has been arraigned as accused number 6 in the aforesaid crime. Apprehending arrest in connection with the said crime, the respondent herein filed an anticipatory bail application before the learned sessions judge on 10th June 2019 and the same was rejected on 25th June 2019. The said order was challenged before the High Court and the High Court allowed the appeal and granted him protection from arrest. Thereafter, the respondent herein filed criminal application APL number 841 of 2019 under section 482 of the CRPC seeking quashment of the FIR dated 12th April 2019 and the charge sheet dated 8th June 2019 to the extent they are against him. The High Court passed the impugned judgment and quashed the FIR as also the charge sheet qua the respondent. Hence this appeal. Before considering the merits of the challenge against the impugned judgment, whereby and whereunder the stated FIR and the charge sheet were quashed, we think it appropriate to refer to certain aspects and also the position with respect to Scope of exercise of power under Section 482 CRPC. Exercise of power under Section 482 CRPC is an exception and not the rule, and it is to be exercised ex debito justitiae to do real and substantial justice for the administration of which alone courts exist. This position has been stated and reiterated by this court time and again. This court, in the decision in R.P. Kapoor versus State of Punjab, held that the High Court could not embark upon an inquiry as to whether the evidence is reliable or not while exercising the power under Section 482 CRPC. In State of Haryana and others versus Bhajan Lal and others, at paragraph 102, this court held that quashing may be appropriate where the allegations made in the first information report or the complaint, even if taken at their face value and accepted in their entirety, do not prima facie constitute any offence or make out a case against the accused, and where the allegations in the first information report and other materials, if any, accompanying the FIR do not disclose a cognizable offence justifying an investigation by police officers under Section 156(1) of the Code, except under an order of a magistrate within the purview of Section 155(2) of the Code. Stop.